Good morning. Welcome to the Kelso Report for Monday, June 11th. I'm your host, Clark Kelso. Welcome to the work week. We began with the Ninth Circuit with a debt collection case involving consumer protection. The Federal Fair Debt Collection Practices Act requires that a debt collector send what is known as a validation notice to a consumer debtor, notifying the debtor of certain rights the debtor has to contest the debt and obtain more information about the debt. Now, the Ninth Circuit has previously held that the Act is violated if a validation letter explicitly states that all disputes must be submitted in writing, since the language of the Act does not explicitly impose such a requirement upon the debtor. You can resolve your dispute orally. However, there is some ambiguity in the Act because two subdivisions require the collection agent to respond to the debtor with certain information, quote, if the consumer notifies the debt collector in writing, close quote, that the consumer wants that information. In Riggs versus Prober and Raphael, the debt collector's validation notice included paragraphs that paralleled those two subdivisions from the Act, and the notice overall might be construed to implicitly require consumers to dispute their debts in writing. Nevertheless, the Ninth Circuit held that even if a notice could be understood to imply a writing requirement, that implication is a result of the statute's own ambiguity, and so such a notice does not violate the statute. As the court explained, it will be untenable to read the FDCPA to prohibit validation notices that simply mimic the statute's own shortcomings. Now, in my judgment, this is not a very satisfactory resolution. The court's job is to resolve the statutory ambiguity and then apply that interpretation to the facts. But the court here essentially perpetuates the ambiguity and gives debt collectors free rein to exploit the ambiguity to the detriment of consumers. It would not surprise me to see an in-bank vote taken on this one. Next, we have an in-bank involving immigration and extradition. In Garcia versus Thomas, the Ninth Circuit in-bank held that a person trying to avoid extradition on grounds that he or she will be subject to torture in the transferee country has a narrow procedural due process right for the Department of State to follow the statute and the department's own regulations regarding how decisions are made regarding torture and extradition. And this narrow procedural right can be protected through a petition for habeas corpus. In particular, the Secretary must consider an extraditee's torture claim and find it not more likely than not that the extraditee will face torture before extradition can occur. That's what the regulation says. Because it was unclear whether that decision-making process was actually followed in this case, the in-bank remanded so the department could submit one or more declarations establishing that the process was actually followed. The in-bank made it clear that the courts have no jurisdiction to consider the merits of the Secretary's extradition decision under the rule of non-inquiry, and that the sole issue here is just whether the Secretary had followed her own processes. Next, we turn to a couple of habeas corpus decisions. The habeas petitioner in United States versus Jingles claimed that the jury instructions given on 2 drug counts constructively amended the indictment in violation of the Fifth Amendment. Well, the same argument had been made with the petitioner on his direct appeal to the Ninth Circuit, and an earlier panel of the Ninth Circuit had rejected the argument. Since the issue had already been decided by the Ninth Circuit, it became law of the case, and since the first panel's decision did not work a manifest injustice, the second panel rejected the petitioner's habeas claim as law of the case. Next, a couple of death penalty decisions. The petitioner, Richard Levin, had been convicted more than 20 years ago and sentenced to death by an Idaho court. The Ninth Circuit has issued 2 prior opinions rejecting his various habeas challenges, and the Supreme Court had denied review. With his execution date approaching, he sought relief under Rule 60B of the Federal Rules of Civil Procedure, claiming that the Supreme Court's recent decision in Martinez versus Ryan now makes him eligible to pursue an ineffective assistance claim on which previously the court said he had defaulted. The Ninth Circuit panel unanimously concluded that the ineffective assistance claim was insubstantial and did not come within Martinez, and that even if there was ineffective assistance, it was harmless. Related to that same death penalty and execution is Associated Press versus Otter. Over the last decade, the state of Idaho has stubbornly refused to modify its death penalty process to permit public and media access to all parts of the execution process, from the moment the condemned is escorted into the execution chamber, including those initial procedures that are inextricably intertwined with the process of putting the condemned inmate to death. Instead, Idaho permits the public to witness only the last portion of the execution process, after the condemned has already been strapped down and had IVs inserted into his or her veins. The right of public access to the entire process has been clearly established in the Ninth Circuit ever since its 2002 decision in California First Amendment Coalition versus Woodford. Faced with this governmental intransigence by Idaho, and with an execution scheduled in the immediate future, the Ninth Circuit panel unanimously ordered entry of a preliminary injunction requiring Idaho to permit public access from the moment the condemned is escorted into the execution chamber. Now, even if the Ninth Circuit's access rule goes beyond what the Supreme Court might approve, I don't have much respect for states that simply flout the law with displays of what amount to governmental civil disobedience. There is a right way to test the law, and simply ignoring it is not the way to proceed. That just generates broader public disrespect for the law and for government. Next, we have an aiding and abetting case from the California Court of Appeal in People v. Smith. The defendant had been involved in a gang altercation where 2 gang members were killed. The defendant was found guilty of aiding and abetting the killings under the natural and probable consequences doctrine, where the evidence established the defendant intended to aid and abet a disturbance of the peace, an assault and battery, which then foreseeably escalated into a violent gang confrontation leading to the killings. The evidence did not establish exactly who shot the victims, and the defendant argued that he could be found guilty under the natural and probable consequences doctrine only if he was aiding and abetting one of his own gang members, a Confederate. The 4th District rejected this argument, concluding that the natural and probable consequences doctrine applied irrespective of whether the defendant's conduct aided and abetted a Confederate or a mere co-participant, someone from the other gang. As the court noted, aiding and abetting culpability under the natural and probable consequences doctrine is not premised upon the intention of the aider and abetter to commit the non-target offense. Instead, the doctrine imposes vicarious liability for any offense committed by the direct perpetrator that is a natural and probable consequence of the target offense. Therefore, it does not matter whether the defendant was intending to aid and abet as to the non-target offense, or intending to aid and abet a member of the opposing gang. Next, an involuntary manslaughter case, a press-worthy case. I'm sure we all remember the defendant in People v. Meserl appealed his conviction for involuntary manslaughter. The defendant here was a BART police officer who shot someone he was trying to handcuff and arrest for misdemeanor obstructing a peace officer. The victim was already on the ground, face down, and the defendant contended that he intended to pull his taser, but pulled his gun instead, shooting the victim in the back. The jury found the defendant not guilty of murder and voluntary manslaughter, but guilty of involuntary manslaughter, essentially finding that he had been criminally negligent. The trial court sentenced him to 2 years in prison. The defendant raised several contentions on appeal, including the evidence was insufficient regarding criminal negligence, the jury was improperly instructed, the trial court erred by not granting a new trial due to newly discovered evidence, and the trial court erred by denying probation. The 1st District rejected all of these weak arguments and affirmed the conviction. The case is newsworthy and publishable simply because of the rarity of a police officer being successfully prosecuted. But there really isn't any new law in this opinion. And that's it for today's Kelso Report. We're at the last 2 weeks of the Supreme Court's term. We have a lot to look forward to in the next 10 days or so, working days. Have a great day in the law. I'll see you tomorrow.